Hey, good morning. It is Mark Weiss. A few minutes ago, I passed an armored car, which made me think about boilerplate. Now, boilerplate, as I've mentioned before in other of these videos, isn't extra stuff in a contract at all. It is the heavy plating around an old boiler, as in on a steamship, that protected things, that kept things tight, that in the contract world keep the rest of the agreement tight. In other words, help to assure that the deal points you negotiated stand a better chance of being enforced. What I want to talk about in particular for a minute or so is the boilerplate provision that deals with choice of law. So what do you mean, choice of law? Well, in a contract, the parties can, with some exception, and we'll touch on that, choose what state's law applies. So for example, two parties in a deal in California, for example, could adopt, just an example, Delaware law, New York law, in connection with the interpretation of an agreement. Now, that requires that you do some thinking about what state's law might be better to enforce the provisions you're looking for. How does a particular state enforce, for example, non-competition provisions? Or how does a particular state's law interpret giving of notice? What makes effective notice? Just as examples, even though the second one might be an ineffective example in that there might not be any difference. But I just want you to understand what the choice of law provision means. Now, in some instances, due to public policy arguments, choice of law provisions might be disregarded. For example, in California, which has very strict statutes governing what types of covenants not to compete can be enforced, in what situations other sorts of similar provisions, non-solicitation, for example, will be enforced. There are public policy reasons why a person who is, say, employed in California by a California employer shouldn't be governed by New York law, even if the employment agreement attempted to import New York law into the interpretation of the agreement. So bottom line is, you're never going to hurt yourself by attempting to choose more favorable law to apply to a contract. But it's a complex issue. In other words, New York law may help you with provision A, but does it help you with provision B, or does that put you in a worse position? So before you go choosing, you need to do some thorough thinking and thorough analysis. But remember, it is one of the tools, one of the boilerplate tools that's available to contracting parties.